Hi, my name is Hye-Soo Shin. I'm very happy to have this opportunity today to talk about international development cooperation and human rights obligations, focusing on economic, social, and cultural rights. Today, we will talk about first on states' human rights obligations, and the next session will deal with ODA and human rights obligations. First, let's deal with states' human rights obligations. First, on current human rights norms. The current human rights norms were first conceptualized more than 70 years ago and have developed gradually over the years into the current system. As we all know, the basic norms and standards were enshrined in the Universal Declaration of Human Rights, which was adopted in 1948. The Universal Declaration of Human Rights was intended to complement the UN Charter with a roadmap to guarantee the rights of every individual everywhere. This declaration was meant to be developed into a legally binding instrument in a shortest possible time frame, that is, within a few years. This scanned document on your right was the Universal Declaration of Human Rights in the UN General Assembly record, both in English and French, while the picture shows Mrs. Eleanor Roosevelt, who played a key role in adopting the Universal Declaration as the then chair of the Commission on Human Rights. However, the original plan to change the Universal Declaration into a human rights convention that's legally binding took much longer, 18 years, and not only one treaty, but divided into two. In 1966, the United Nations adopted two covenants. One is the International Covenant on Economic, Social, and Cultural Rights, which is called ICSCR, and the other is the International Covenant on Civil and Political Rights, ICCPR. The two covenants were supposed to protect all human rights of all persons. However, particular topics such as torture and kidnapping continued to occur, and particular groups were more vulnerable and needed more attention and protection. Hence, more human rights treaties were developed and adopted, such as you see on the screen, against racial discrimination, also against discrimination against women, against torture, children's rights and migrant workers' rights, rights of persons with disability, and to protect people from enforced disappearances. So currently, there are 9 core human rights treaties. Under the current human rights treaties, the states, which means governments, but of course as well as legislative and judiciary body, have obligations to respect, protect, and fulfill the rights of everyone. Obligations to respect means that the state itself should not violate the rights of people. Here, the state means the government, public agencies, law enforcement officials, such as police or prosecutors, or whoever belongs to the government and any public agencies. Obligation to protect means that the state should protect people against any human rights violations by a third party, whether it's business companies or individuals. Obligation to fulfill means that the state should take steps to fully realize the rights guaranteed under each treaty. These are the principles which are common to all these 9 core human rights treaties. These are, 1, the principle of non-discrimination, and second, the principle of gender equality. Principle of non-discrimination is prescribed in both ICSCR, the International Covenant on Economic, Social, and Cultural Rights, and ICCPR, International Covenant on Civil and Political Rights. In Article 2, both in similar languages. In ICSL's Article 2, Paragraph 2, any kind of discrimination based on any grounds is prohibited. As you see, such as to race, color, sex, language, religion, political or other opinion, national or social origin, property, birth, or other status, which includes all the other status. Although the original language does not include, for example, age, disability, or health, those are all included. Likewise, the ICCPR on civil and political rights prohibits any discrimination based on any ground, exactly in the same language, whether in law or in practice. In addition to the prohibition of discrimination, the state also has to ensure the equal rights of men and women in all areas of economic, social, and cultural rights, as well as in the areas of civil and political rights. So in Article 2 of both ICSCR and ICCPR, discrimination on the basis of sex is already prohibited, and the state try to fully realize those rights. The state, furthermore, has to ensure equality between men and women so that women can equally enjoy and exercise all these civil and political, economic, social, and cultural rights. Now, about states' human rights obligations. We will talk about obligations under the International Covenant, particularly focused on economic, social, and cultural rights. International development cooperation and assistance are closely related to economic, social, and cultural rights, so we will explore more what kind of rights we are talking about. First of all, in the International Covenant on Economic, Social, and Cultural Rights, there are work-related rights. Everyone has the right to work that a person has freely chosen or accepted. The working condition has to meet the standards, such as adequate wages and healthy working environment without sexual harassment, no discrimination in hiring, training, promotion, and retirement. This is right at work, which is guaranteed in Article 7. Also, the worker has the right to join trade unions and participate in the trade union activities, including the right to strike. So these work-related rights are from Article 6, 7, and 8. Right to Social Security, guaranteed in Article 9, means everyone is entitled to social insurance, social protection, and social assistance. Article 10 guarantees the right to family. The family, as a basic unit of society, should be protected and assisted, especially for mothers and children. Article 11 of the International Covenant on Economic, Social, and Cultural Rights talks about everyone's right to an adequate standard of living, including adequate food, clothes, and housing. An adequate standard of living also includes right to water and sanitation, as well as clean environment and measures to tackle climate change. Right to health, in Article 12, both physical and mental health is critical while we are living now in the era of COVID-19 pandemic. Next, right to education is also a basic right, since education is very much linked to employment and social security in later years. Finally, Article 15 guarantees right to culture. Culture is very important, in particular for the minorities and indigenous peoples. Now, look at how international cooperation and assistance is considered by the International Covenant on Economic, Social, and Cultural Rights. As you see on the screen, Article 2 of the International Covenant says that each state party to the present covenant undertakes to take steps individually and through international assistance and cooperation, especially economic and technical, to the maximum of its available resources. So the covenant provides that when it is difficult for a country to fully realize the economic, social, and cultural rights of its people, international cooperation should be sought, especially in the areas of economic, social, especially in the areas of economic and technical assistance and cooperation. Also, the international cooperation is essential for an adequate standard of living, which is guaranteed in Article 11, and to improve people's living conditions. Article 11 of the International Covenant also mentions the international cooperation to ensure everyone's right to be free from hunger. The state party should take measures to secure food and through international cooperations, as you see in Article 11 to 8. Also, in the areas of science and culture, international contacts and cooperation are also important. We are all witnessing the importance of international cooperation under the current situation of COVID-19 pandemic. The final part of Section 1 is regarding the human rights obligations outside of territory, which is called extraterritorial obligations. The state, when it is operating extraterritorially, such as through ODA, it has human rights obligations. Within a state territory, we have regulations by national laws, and outside of the national territory, we have extraterritorial obligations. Nowadays, businesses play an important role in the realization of economic, social, and cultural rights inter alia by contributing to creation of employment opportunities and through private investment to development. When the business companies operate inside a country of its origin, they are regulated by the national laws. Many business corporations at the same time operate internationally, which is referred here as extraterritorial. In addition, the state has also human rights obligations regarding the activities of business corporations overseas, so that there are no human rights violations. These human rights obligations apply throughout the supply chains. The Committee on Economic, Social, and Cultural Rights adopted its general comment number 24, as you see on the screen in the document, on states' obligations regarding business activities in 2017, in which the extraterritorial obligations were emphasized. On your right, you see the UN Human Rights Council's adoption of guiding principles on business and human rights. In this session, we have covered what the current international human rights norms are, and in particular, the norms regarding the economic, social, and cultural rights under the International Covenant on Economic, Social, and Cultural Rights, as well as the state's obligation for international cooperation and assistance, including extraterritorial obligations. The topic of session 2 is about ODA and human rights obligations. Let's look at the international target of ODA amount and what is required when ODA is given. The developed countries, that is OECD member countries, are expected to provide 0.7% of their gross national income as ODA. The target of 0.7% of GNI as ODA was internationally agreed in 1970. As you see, however, in the chart, currently only 5 countries are doing their part, giving 0.7% of GNI. In February 2020, the Committee on Economic, Social, and Cultural Rights reviewed Belgium's compliance with its obligation under the covenant. The committee, in its concluding observations on Belgium, recommended to the state to increase its ODA to 0.7% of GNI. You can see the committee's concern and recommendations. In addition to meeting this international commitment, it is essential to conduct human rights impact assessment in the planning and implementation of ODA, because a good-intentioned ODA can bring negative impacts in the lives of people in the receiving country. The Human Rights Charter of COICA well describes this principle of human rights impact assessment. Now, let's take some examples to understand why human rights impact assessment is necessary before starting an ODA project. In Turkey, now they changed their name into Turkey, there was a dam which is called Ilısu Dam. And the Ilısu Dam project was to build a mega-size hydropower plant on Tigris River, which will affect 78,000 people living along the river, including the tens of thousands old village, without free, prior, meaningful consultations of those people who would be affected. They were mostly ethnic minorities in the north of Iraq. In 2009, the government of Germany, Austria, and Switzerland withdrew their export credit guarantees because the project did not meet human rights standards. As you see, these people, those who are living there, if the dam was constructed, the whole village and those regions will be swamped by water. The Committee on Economic, Social, and Cultural Rights reviewed the reports of Turkey on its implementation of the covenant obligations. In 2011, the committee expressed its concerns about those people who would be affected by the dam construction, the first eviction of people, and displacement and resettlements, as well as adequate compensation of the affected people. Likewise, the dam construction will cause negative environmental and cultural impact. The committee recommended human rights-based approach in the development projects and the complete review of all legislations in this context. Next, we are going to look at an example of German ODA to Cambodia on land titling. In the process of land titling, the poor households who had possession rights became vulnerable to forced evictions because they live on land that is sought after by powerful individuals and companies. Authorities have also refused to issue titles to such households despite evidence of valid possession rights. The project has failed to provide secure land tenure to many of the most vulnerable households. The committee's concern and recommendations show that when development cooperation is provided, human rights impact assessment should be conducted in advance, as well as monitored during the implementation of the project. International cooperation and assistance take many different forms. Norway's pension fund Global invested to companies in Israel, which found to be engaged in home demolition, Israeli settlements, or other activities in the occupied Palestinian territory. Whether given as direct ODA or in the form of investment, all international corporations should meet the human rights standards and obligations. So the committee recommended to Norway to review the investment of the government pension global fund in business entities involved in operations in the occupied Palestinian territory. Now we will look at state accountability and remedies for victims. The committee reviewed the case of Korea in 2017 and raised concerns regarding public financial institutions not linking the provision of loans and grants to companies and projects to human rights requirement. And the committee recommended that Korea should act upon allegations of violations of human rights resulting from activities of Korean companies and ensure that victims can claim reparations through the state parties' judicial and non-judicial mechanisms. We have covered 3 topics in this session. Those are, first, the developed countries should try to meet the target of 0.7% of their GNI as official development assistance. This is an internationally agreed commitment made back in 1970. When international cooperation and assistance is provided, the project should meet human rights standards. Second, I gave several examples of different types of international assistance. There can be diverse forms of human rights violations which should be avoided from the start. Third, governments should be accountable for any violations, whether by state actors or businesses and other non-state actors, and provide proper compensation. Thank you very much for giving me this opportunity to talk about international development cooperations and human rights obligations today.
Hi, this is Sejong Park. I am the moderator of the online human rights course of KOICA today. Now I'm here with Hae-Soo Shin, the chair of the board of the Korea Center for United Nations Human Rights Policy and a current member of the United Nations Committee on Economic, Social, and Cultural Rights. She gave us a great lecture on international development and cooperation in human rights obligations today. We also have Yeonjae Choi, the manager in the Social Value Innovation team. He is currently in charge of the ESG management in KOICA and used to work in several overseas offices, including Afghanistan and Fiji. All right, before we begin, I would like to ask you to share your perspective on this lecture. So how was the lecture today?
Yeah, first of all, it was a great honor to having me here to have an insightful lecture. Since I'm working in the KOICA, I personally believe that human rights are important, but I was not aware of details of principles and obligations. However, through this lecture, it was a meaningful time for me to learn about the human rights obligation that must be observed. As a person serving in the field of international development and cooperation, especially in this session too, I became aware that the human rights violations due to development assistance, and thought that I should carefully follow the major principle and procedures to prevent human rights violation throughout the project cycle, and try to reflect the human rights principles and norms into our project and our management system.
Yes, we are on the same page, and especially it was a very meaningful experience for people like me who did not have much prior knowledge on human rights or international development. And while listening to the lecture, I wanted to ask you a question. As KOICA is mainly established to promote the quality of life of people in the developing countries, it is still hard to imagine that the KOICA's projects can harm the rights of local people, even though I listened to the lecture. So, Professor, could you explain how it can happen without sufficient considerations on human rights?
The most important thing is to establish a system where a human rights-based approach is applied to all international development projects. The human rights-based approach needs to be implemented by all. I mean, not only by COICA, but also all development partners, such as the government of the recipient country, businesses involved throughout all the supply chains, and civil society organizations. All development partners should understand human rights-based approach. In the case of Turkey, now renamed as Turkey, the government pushed, as I said in the lecture, the Ilisu Dam construction despite the heavy criticism against human rights violations, such as forced eviction and environmental destruction. How to enhance the understanding and implementation of human rights-based approach by all is a challenge.
Thank you very much for your explanation. Professor Shin has mentioned the importance of respecting and protecting human rights by establishing an adequate system within organizations, and as well as applying it to development partners. So, Mr. Choi, I have a question. How are the UN principles and recommendations reflected in COICA?
COICA has always valued human rights. COICA has made a significant progress in 2018 and declared its Human Rights Charter and Human Rights Code based on the Universal Declaration of Human Rights and the UN Declaration on the Right to Development, and also the UN Guiding Principle on Business and Human Rights. Regarding the Human Rights Charter, COICA has established 10 principles reflecting the major principle of Busan Partnership for Effective Development Cooperation and the UN 2030 Agenda for Sustainable Development. Also, our Human Rights Code including 13 principles such as prohibition of discrimination, gender equity, and the human rights-based approaches. COICA is also making hard effort to comply with this principle throughout its business operation. In order to prevent human rights violation, COICA is conducting human rights impact assessments on the project management. And all our new project and development consulting program and public-private partnership programs, we are also constantly trying to improve our grievance redress mechanism.
Yeah, as you mentioned, COICA has already made quite a big progress in such a short period of time. So, Professor, I heard that you are a member of the Gender Committee in COICA and also wrote on the reality of gender-based approach, focusing on COICA's examples. So how would you evaluate, or how much do you think the international development institutions like COICA or many other organizations in Korea have made progress in adopting human rights-based approach?
I think COICA has been an outstanding model in adopting human rights-based approach in its management and operation. During the last 10 years, and in particular since 2018, COICA has been mainstreaming the human rights-based approach into all aspects of its work, while also exploring new development projects to improve the human rights of disadvantaged and marginalized groups, such as people with disabilities, children, youth, and women. Despite these remarkable progresses, however, I feel that these efforts are shown more on paper rather than fully understood and internalized by all members of COICA. For example, in the paper, the principle of AAAQ was mentioned. AAA means availability, accessibility, acceptability, and quality, which can be applied to many areas such as health, housing, education, etc. If we apply AAAQ to the health and well-being, the healthcare facilities, services, goods, and information should be available, accessible, acceptable, and of good quality, whether someone is poor or disabled or sexual minority. Likewise, inside COICA, I know that sexual harassment or discriminatory remarks are prohibited. But if you are working in a country with very high level of discrimination towards minority groups, or if there is prevalent sexual harassment, how will you deal with this situation? There should be more case studies in various different settings, and there should be continued discussions among members of KOICA while working in this situation.
Yeah, as you mentioned, we need more case studies, right? All right. Your lecture was mainly focused on economic, social, and cultural rights. Although all rights are important, is there any specific area of economic and social and cultural rights that you consider to be the most important, or that you wish that the development institutions should focus on the most?
I think it depends on the country that you are working in and the time. In these days of COVID-19 pandemic, of course, health is one very important area. The Committee on Economic, Social, and Cultural Rights issued 3 statements so far on COVID-19, how the pandemic affects right to work, right to social security, or right to education, and also a statement on the point that vaccination should be universal and without discrimination. For people in Ukraine, right to life and security, along with the right to food and water, should be most important at this time. In Afghanistan, women's basic rights should be more important. So I think it depends on the country and when you are working with the country.
It seems like much effort is still needed to fully fulfill economic, social, and cultural rights in the field. So, Professor, what kind of efforts are further required for development institutions and people working in the development cooperation to promote such rights?
I think KOICA and people working in the development cooperation need to study what are the root causes of inequality and human rights violations in that particular country. Is it because of rivalry between ethnic or religious groups in conflict? Or is it because of bad governance and corruption? Or is it due to prejudice and social exclusion? Or simply due to ignorance? For example, in order to promote inclusive education for children with disabilities in a particular country, the government first needs to collect accurate data on how many children with disabilities exist in the first place, and with what type of disability, as well as age and other criteria, and should secure enough number of trained teachers, make schools physically accessible, etc. At the same time, in order to correctly understand the root causes of inequality and discrimination, we need to develop our own human rights sensitivity and understanding, which will require continuing education and awareness raising on human rights among those working for development cooperation.
Yeah, we need to study roots first. Then, Mr. Choi, could you tell us a little bit about the future plans of KOICA to promote these rights?
Right. First of all, regarding her advice, we published the Human Rights Analysis Report on 27 major partner countries, and we are planning to use it as a reference for developing new projects. Also, we will continue providing human rights courses like this to the person concerned, such as our employees or our partner, to improve their understanding of human rights. Finally, we will try to spread the importance of a human rights-based approach to our partner institutions and provide them useful information and tips on the implementation of human rights-based management.
Thank you very much for sharing your opinions. All right, this is the last question, Professor. Is there anything you want to say to the employees of KOICA and partner institutions and many people interested in this field watching this course?
Yes, Korea is a country which experienced all sorts of atrocities and challenges, such as colonization, war, poverty, and dictatorship. However, with considerable international development assistance, together with the Korean people's own efforts, Korea was transformed to rise from ashes and became a donor country now. With these experiences, KOICA, as a leading Korean institution for international development cooperation, can be more ambitious, I think. Let's strive to be a model donor agency in terms of respecting, protecting, and fulfilling human rights. I hope KOICA can expand its human rights work while also respecting human rights obligations, as well as leading in developing new agenda in its various human rights networks. I really hope so.
Thank you very much. Thanks to Professor Shin and Mr. Choi, we could have the great opportunity to share our opinions and learn more about human rights and international development cooperation. Thank you very much for your sharing your opinions and taking your time. Thank you.
Thank you.
Thank you.